Hello, thank you for joining me this afternoon to go through a webinar entitled Playing a Part in Litigation. This webinar is primarily aimed at executors or administrators for estates and those acting for executors. And what we're going to be looking at today is what you or your client should do if a claim is intimated against the estate. I was meant to be doing this webinar with Ryan Taylor, but unfortunately he's unwell today, so I'm also going to be doing his part of the talk. So there are many ways in which a claim can be made against an estate, covering a multitude of different issues. But for today's purposes, we're going to be primarily focusing on probate claims and claims under the Inheritance Provision for Family and Dependants Act 1975. In the case of probate claims, these most commonly are encountering issues where there's a lack of proper formalities relating to the execution of the will, lack of capacity by the testator, want of knowledge and approval in relation to the contents of the will, undue influence where the testator is overpowered by the influence of another such that the will is not their own, an act of fraud, usually in relation to the creation or execution of the will, and acts where there's a challenge that a will has been revoked by an earlier or later will. And it's very common that within the probate claim portfolio, we most often see claims concerning lack of testamentary capacity. And you'll all be familiar with the case of Banks and Goodfellow, which is an 1870 case, which requires that for the will to be validly executed, a testator shall understand the nature and act of making a will and its effects, the extent of the property of which he is disposing. They shall be able to comprehend and appreciate the claims to which they ought to give effect, and that no disorder of the mind shall poison his affections, that no insane delusion shall influence his will. And so that is the rubric for looking at validity in the context of testamentary capacity. It is, as I say, it's a very common issue to see that crop up in practice. And a survey by Direct Line Insurance in 2019 reported that 1 in 4 people would challenge a loved one's will if they were unhappy about how the estate had been distributed. And we see this ourselves as litigation lawyers in contentious probate in terms of the number of inquiries that we get. And the probate registry figures also reflect this. In 2017, the registry indicated that claims where there were around 8,000 caveats registered to try to block probate that year concerned disputed wills and estates. So it is indeed a very common issue that crops up, and you will know, I'm going to come on to talk about the golden rule a bit more, but you will know as practitioners the importance of obtaining medical evidence and obtaining your own evidence around the testator's mental state at the time the will is made, and that there is usually a presumption of capacity if a will appears rational on its face, and by that we mean that it appears in proper form, it's validly executed, signed in writing, witnessed, and signed by the testator. And in those circumstances where a will appears rational on its face, there's a presumption that it is a valid will. But if evidence is raised by the person trying to challenge that will that raises doubt about its validity, then the presumption shifts, the presumption is rebutted and the evidential burden shifts onto the party propounding the will to prove that the testator had capacity. So that's just, I mean, as you are in the where you are acting as an executor or your client is an executor, you're not so worried about that, but that's just the context in which a probate claim works. So the golden rule is certainly where non-contentious practitioners will be looking to shore up their own work, and I'm sure you will be familiar with the golden rule, which is derived from the Kenwood and Adams case where the court held that in the case of an aged testator or a testator who has suffered an injury, there is a golden rule which should always be observed. The making of a will by a testator ought to be witnessed or approved by a medical practitioner who satisfies himself of the capacity and understanding of the testator and records and preserves his examination and findings. So again, good practice indicated by the golden rule is obtaining the medical letter and discussing any earlier wills with the testator, and taking instructions in the absence of anybody who stands to benefit from the will or could exert influence over the testator. And it isn't determinative once you've obtained the medical evidence, but it is going to be very persuasive if this ever came to light in the context of a probate claim. And it isn't an absolute obligation on you, but it is good practice. And there have been circumstances in the past where the court has held that the solicitor was essentially at fault in failing to adhere to the golden rule, and where a probate claim was intimated and then followed through as a result of that solicitor's failing, that solicitor was ordered to pay costs in relation to the probate claim. So that is something that you will certainly be looking to guard yourself against. And you should also be considering the worst case scenario of a probate claim, particularly where you're acting for a vulnerable testator. And you may want to keep in mind what may be required of you at a later date if a probate claim is commenced. And you most often find that the first time you hear about a probate claim being on the table is if a Larke and Nugus letter is sent to you. And I'm going to come on to talk about Larke and Nugus letters and what you should do when you get one. But essentially they are requests by potential claimants for information relating to the steps that you took when you took instructions from the will and the evidence that they may or may not rely on in relation to your contact with the testator, because the court has historically placed a huge amount of weight on the solicitor's evidence as to capacity. So you should bear that in mind and ensure that you do have a clear record and understand and are aware of the testator's capacity. Think about undue influence. Make sure you understand what the testator is looking to achieve, their knowledge of their own acts, and think about any external factors that might influence the testator's judgment, and ensure that you keep a record of all these considerations, as well as keeping a clear documented medical report on your file for future reference if it ever arose. So where I talk about Larke and Nugus letters, you'll be familiar with the case Larke and Nugus, a 2000 case, where the court held that where there was a serious dispute as to the validity of a will beyond the mere entering of a caveat, and the solicitor's knowledge makes them a material witness, then the solicitor should make available a statement of their evidence regarding the execution of the will and the circumstances surrounding it to anyone concerned in the proving or challenging of that will, whether or not the solicitor acted for those who were propounding the will. So that's a long way of saying that you as the solicitor are going to be a key witness. And when you receive a Larke and Nugus letter, it's probably going to be quite lengthy. It's going to notify you that the solicitor who you're receiving the letter from is acting for a disgruntled beneficiary, probably, or is potentially acting for somebody who wants to uphold the will and wants to be able to rely on your evidence to prove that the will is valid. And you're likely to get asked a number of questions. And as I say, those questions might come from different angles depending on who is writing you the letter, whether they're writing it in a way to suggest that you took instructions from somebody who lacked capacity and your assessment was wrong, or somebody who wants to use your evidence in support of their position. So those questions could, as I say, take a number of different alternative perspectives and routes, but commonly you're often asked who introduced you to the deceased. So somebody might be interested to know whether or not it was a son or daughter who was trying to get their elderly parent to see a solicitor to do a will in their favour. So you should certainly be clear at the time you take instructions about that introduction. How are the instructions expressed in writing or on Zoom or over the phone or in person? What indication did the deceased give you that he knew he was making a will? Were you informed or otherwise aware of any medical history of the deceased that might bear upon the issue of capacity? To what extent were earlier wills discussed, and what attempts were made to discuss departures from his earlier will? And who, apart from the attesting witnesses, was present at the execution of the will? Where, when, and how did this take place? And these are not standard questions, but these are the sorts of questions that are likely to be asked. And again, with reference to my earlier slide, these are the sorts of things one wants to keep in mind at the time of taking instructions, because these are all examples from cases that have been before the courts as to the sort of information and evidence that might be relied upon or sought from the solicitor. Now, the Larke and Nugus letter would often ask you for a copy of the file and all the information about what was discussed with the deceased. But you do need to think about your legal obligations in the relation to privilege. You owe a duty of confidentiality as a will drafter to the deceased, and you also have professional obligations. And that duty of confidentiality to the deceased doesn't automatically end on death. That duty continues. The SRA Code of Conduct Rule 6.3 requires that you keep the affairs of current and former clients confidential unless disclosure is required or permitted by law or the client consents. And you'll find a very useful guidance online from the Law Society. It's the Disputed Wills Guidance for Practitioners page on the website for the Law Society, and I would direct you there if you do have concerns about what you should do in certain situations relating to confidentiality and privilege. But what I can tell you is that you can obtain authority to disclose information and essentially waive privilege, and that can come from certain sources. So there may be instances where the testator is alive where you could obtain that authority. On death of your former client, the testator, the privilege vests in the personal representatives. And so the professional representatives can give you authority to provide a response to the Larke and Nugus letter and provide disclosure of your file. The court can certainly make an order for disclosure and evidence from you. And you may find that there are some other form of statutory authority, or in the case of a third party, you may be able to obtain that authority where there are mutual and mirror wills. But it is important that you're clear about where that authority is coming from and you take steps to obtain that authority before responding. When you do respond, it is important to be thorough in your Larke and Nugus response. You can be criticised at a later date if you don't give full answers and then later produce evidence that could have had a bearing on the way the case progressed had you provided it an earlier date. You should be prompt and not leave the response outstanding. And you should enclose a copy of the full file for the will instructions if you have that authority. But they can take time to complete the Larke and Nugus letters. Sometimes it may be a matter of years ago that you acted for the testator and you don't have the facts close to hand, so you will need to spend some time refamiliarising yourself with the file in order to provide the response sought. It is now the position that charging for the preparation of the response to the Larke and Nugus letter is permitted. It never used to be, but now it is. However, there is no guidance on what you should be able to charge, just that it needs to be reasonable. So I would recommend that before you undertake the work and provide the response, simply acknowledge the letter in short terms and ask to agree your fee for complying with the request. And that's perfectly reasonable. And I think failure to for the requesting party to agree that could be unreasonable. If you fail to respond, there could be adverse costs against you if the matter becomes litigious. It could also entail a complaint to the SRA for failing to comply with your obligations as a professional. And you may find yourself on the receiving end of an application against you under Section 122 of the Senior Courts Act, or Section 123, which I'll come on to in a moment. And you could also be faced with an application for pre-action disclosure or third-party disclosure under the CPR Rules 31.16 and 31.17, where the court may can order that you produce disclosure, and you could well be ordered to pay the costs if you had an opportunity to do that and brought about the application as a result of failure to respond. Now, Section 122 of the Senior Courts Act is a requirement for you to attend for examination. And the right to make such an application arises where it appears that there are reasonable grounds for believing that any person has knowledge of any document which is or purports to be a testamentary document. The High Court may, whether or not any legal proceedings are pending, order him to attend for the purpose of being examined in open court. And you would then be required to answer any question relating to the document or bring in the document in a manner that the court may direct. If you fail to adhere to any order under Section 122, it is a contempt of court situation. So clearly, you don't really want to be faced with that and unable to deal with anything. Section 123 is a subpoena to bring in a testamentary document. So if you have the will in your possession, custody or power, which purports to be a testamentary document, the High Court can subpoena you to bring the document in. Now, you may find yourself in an invidious position of being threatened with these applications, obviously not wanting to be on the receiving end of them or certainly facing any cost sanctions in relation to them, but without the consent or authority of the testator, as it were, for producing the information that's required. In other words, you're still bound by privilege. So in those circumstances, I'm sorry, I'm doing my slides backwards here, but in those circumstances, if you're acting for an executor who simply doesn't want to waive privilege, and that's their right, you must, it's incumbent on you as their lawyer to advise them of the potential risks that they're facing if they don't waive privilege. I would also recommend that you notify the author of the Larke and Nugus request that that you're bound by privilege. And I would also recommend that you indicate to them that you do not oppose an application for examination or a subpoena. And that should give you some degree of cost protection if you can explain that you're bound by privilege, but you won't object to an application being made against you. And then in that way, you're sort of letting the court put matters into their hands. And once the court has made an order requiring you to do something, that will mean that you're not going to be in breach of your professional obligations under the SRA Rule 6.3 that we looked at earlier, because the court has made an order requiring you to do something. The other reason for not responding to a Larke and Nugus letter that I've put at the first bullet point of the slide is that in your view there's no real issue of dispute and that the claimant is simply on a fishing expedition. So that means you're taking a fairly robust stance to what the claimant is potentially looking to argue, but do think about what the risk of taking a position against the claimant is in relation to that, because you could face the risk of adverse costs. It's highly advised to take some professional advice about the merits of any potential claim against the will and what's being indicated in the letter before you say no, just to protect yourself if anything were to later be used against you in that respect. So I'm now going to look at specifically the actual process of a probate claim going through the court. And although I think we're all clear from my introduction of what I'm talking about in relation to a probate claim, I think it's worth identifying the specific provisions of the CPR, the Civil Procedure Rules, because that clearly defines probate claims as a claim for grant of probate or letters of administration, a claim relating to the revocation of an earlier grant, or a decree pronouncing for or against the validity of a will. And you'll find that within Practice Direction 57.1, subsection 2. It does not include a claim under the Inheritance Provision for Family and Dependants Act 1975. That has its own regime within the CPR, which I'm going to come on to, but is not, strictly speaking, a probate claim in the purest sense. A probate claim is governed by Part 7 of the CPR. So it's often going to be dealt with in the multi-track. There's going to be cost budgeting, there's going to be standard directions relating to disclosure, witness evidence, expert evidence, then case management, pre-trial review and a trial. So it will go through the sort of standard process. And as many of you who've been involved in these will know, it can potentially take 18 months to 2 years. Please also bear in mind that Part 21 of the CPR will apply if the claim concerns children, and that requires children to have a litigation friend, and they'll often have their own solicitors through the litigation friend acting for them. And if there isn't a caveat already in place, which is very common where a dispute has arisen in relation to the will validity, then just the fact that the probate claim has commenced itself prevents the grant of probate from being obtained unless it has already been granted. So it is in a sense a block against a probate going through. Now, who should be made party to a probate claim? Part 57.61 of the CPR requires a claimant to join all those entitled to administer the estate where revocation or grant of letters of administration is sought. So that would mean that you or your client would be joined as a party to the litigation. And as a result, there are certain things that you must do, which I will come on to talk about. Also be aware that it is possible to join all those who may be entitled to provision under the Inheritance Provision for Family and Dependants Act to be joined, and all people with interest in the estate, and also creditors. So it's a fairly large class of potential parties to the action. And one of the things that we often get asked about is whether or not a neutral administrator can start a probate claim, because you'll be aware that where you're acting as an administrator or for an administrator and there is this big dispute going on between the beneficiaries of the estate around the will, then what can you do, particularly where there's a stalemate? You want to get on with administering the estate, but there's a dispute that nobody wants to start the claim. Perhaps this has been going on for a year or more and there's a sort of stalemate. And I think some people perhaps think that Part 64 is the correct way to get in front of the court as administrator or executor and say, give us directions on what to do. But actually, you can just go straight in with a Part 57 probate claim. It's perfectly possible to be the claimant where two sides can't agree, start the claim and simply tell the court that you're starting the claim. You're leaving it to beneficiaries to fight it out, join them as defendants, and say that you as claimant are bound by the court's decision. And that's certainly one way to cut to the quick and get the parties to thrash out the issue and put it before the court. It's quite unusual because most of the time one of the parties will eventually start the action, but where there is an ongoing dispute and nobody really wants to actually make the claim, put the claim on foot, then you can do that. And it's important to remember that you must lodge a statement of testamentary documents if you are the claimant at the time that you start the claim, and you should remain neutral. That doesn't, just because you're the claimant, that doesn't affect your neutrality or your obligation to the estate not to wade in. So the statement of testamentary documents is a CPR requirement, and as I say, if you are the claimant, it must be lodged when you issue the claim, and if you're not the claimant, then it should be part of the particulars of claim and the evidence that's served on you at the time the claim is issued. If you're the defendant, you must file your own statement of testamentary documents with an acknowledgement of service. And that is in the form of an affidavit or a witness statement. The CPR requires it to be signed by the party personally and not by the solicitor, unless that party is a child, in which case it can be signed by their litigation friend or their solicitor. The form of the statement you will find helpfully in Annex PD 57A of the CPR, and that actually creates a template for you to complete. It's not complicated. It just simply sets out your knowledge in relation to the testamentary documents and their whereabouts. And the rules provide that no party can inspect another party's documents until they have filed their own evidence of testamentary documents, unless the court gives permission, and that's in part 57.55. Now, what to do when you receive a claim? Let's assume that you're not the claimant, you're the defendant, and how should you respond? Again, we just look to our trustee CPR rules, and 57.4 obliges a defendant served with a claim form to file an acknowledgement of service, and that's within 28 days of service of the particulars of claim. Now, in the normal Part 7 procedure, where a defendant fails to file an acknowledgement of service, the claimant can proceed to obtaining a default judgment. However, Part 57.10 specifically excludes default judgments from probate claims. So where the acknowledgement of service is not filed, a claimant can apply to court for an order that the claim is to proceed to trial in the absence of the acknowledgement of service. However, you will, of course, want to file your acknowledgement of service, and so this is what you will be looking at when you complete the form. It's the standard court form N9, and I've just circled here what the typical response would be. I do not intend to contest this claim. In other words, you or your client will remain neutral, and the testamentary documents of the deceased, either box here will apply depending on the circumstances, but you must select one of these boxes. Either the documents are in the described in the attached witness statement, or you don't know about any testamentary documents. And then there's a section which doesn't apply unless the claim is specifically seeking a revocation of a grant of probate or letters of administration. And in that case, you have to notify the court and the other parties whether the probate grant or the letters is under your control or not. And your acknowledgement of service form will need to be filed with the court and served on the other parties. There are certain applications that might be made against you as a defendant to the claim, specifically relating to the production of testamentary documents. I've already talked about section 122 of the Senior Courts Act, and that can still be made separate to the probate proceedings. That application can be made in parallel to that, and it can be made without notice. So to avoid those sorts of scenarios happening, you should file written evidence to set out clearly whether or not you do or do not know of the existence of a will, whether it's in your possession. The other sort of application that you might find is made by one of the parties that would particularly concern you or your client is for an administration pending suit, and that's within Part 57.8. So where a long and drawn out probate claim is envisaged that, as I say, might take up to 2 years to conclude, the parties might be mindful that the estate will need to be dealt with in that time, because there is, as I say, either a caveat at preventing the administration, or the fact that the probate claim has been issued means that no grant can be obtained until the probate claim is determined. And so in that time, the court would only be able to allow a grant to be obtained if it was an interim administration pending suit grant that allowed an executor to call in the assets on an interim basis and deal with them during the course of the claim. Now, there is provision for remuneration within 8.22 in Part 57, and so that's clearly going to be of concern to you and your client. And when responding to the application, or indeed making the application on behalf of the defendant, then you certainly would want to be seeking authority within the order to be remunerated for the interim administration. So they are the main areas of concern as far as dealing with the receipt of a notification of the claim and the potential applications that might be made that are of concern, particularly to you or your client. And really, you can sit back and allow the parties to fight it out, of course, providing the court with as much support as you can in relation to evidence, which I touched on in the context of the Larke and Nugus request. So hopefully, with the passage of time, the parties can get towards a position of settlement. And there are different ways that a claim can be settled. Obviously, the court would have to approve the settlement ultimately, or the discontinuance probate claim. And you will need that, because the court will need to make an order that a will can be propounded, or that a grant can be obtained. And so there are different ways that a claim can be settled, but really you will want the pronouncement for or against the validity of one or more of the wills. That's often the most frequent and important thing that we see. And quite often the parties might want to conclude a settlement by entering into a deed of variation. And you, as administrator, should be mindful that all beneficiaries affected by variation need to be party to that settlement. So that's something very important to bear in mind. The scope of this talk doesn't really encompass the specifics of deeds of variation, which in themselves are quite a specific area, but we do quite frequently see them used as a device for settlement. And of course, costs have to be dealt with as part of any settlement or final determination of a claim, and costs are within the discretion of the court. But the general rule in probate claims is that costs follow the event. So you will find that costs are not usually borne by the estate. So as far as your costs of acting for or as the administrator of the estate go, they are usually paid on the indemnity basis, but they are paid out of the estate. And the winner usually is paid, has their costs paid by the loser. So that's the general position. But there are some pitfalls to be mindful of. If you or your client do not remain neutral as executor, that can lead to adverse cost consequences. How do you avoid that? Well, obviously, stay neutral. Don't take sides. Try not to express an opinion one way or the other in your correspondence, or certainly in your evidence. Cooperate with both sides, engage equally with both sides, and assist the court as far as you can. If you do not take, if you don't do that, then you may be liable for cost consequences. But there are some exceptions to that. It may be that a group of beneficiaries who stand to benefit from the will want to come together and ask you as executor to effectively act on their behalf to propound the will. And in those circumstances, there's nothing wrong with that. You can do that. That's allowed. But you do not want to be facing the bill for acting essentially as the representative of a group of beneficiaries who stand to gain, without some protection for your costs. Because if you were to be unsuccessful, then you may well end up paying the other side's costs, and you don't get your own costs paid. So you would want to come to some sort of an arrangement outside of the court's own costs management powers, but to ensure that those beneficiaries are going to give you some indemnity if you do take that. And then, again, there's nothing wrong with that. It's not part of the CPR provisions, but it's something that works and is practical if that scenario were to arise. So I'm going to briefly talk about claims under the Inheritance Provision for Family and Dependants Act 1975, and this is a whole webinar in itself, and there's all sorts of different aspects of the Inheritance Act that we could talk separately on. So I'm not going to look at and analyse the Act in high level. I'm going to look at it specifically from the point of view of the executor when a claim is made. So it isn't a probate claim, as I said. It has a separate procedure, and that's the Part 8 procedure. And the rationale for that is that it's a much quicker and more evidential basis rather than needing heavy disclosure and separate case management cost procedure, etc. And so there's typically no cost budgeting in these cases unless ordered by the court, and they can be dealt with a bit more. In theory, they can be more streamlined in terms of case management. Claims can be issued before a grant of representation is taken out. The law changed several years ago on that. There is a 6-month statutory limitation from the date of the grant to make the claim, but this can be extended by the court at their discretion under Section 4 of the Act. And there's a whole wealth of case law just on that particular topic, because the Act is very, very case sensitive. But it's fairly common to see the court extend its discretion to allow claimants to issue out of time if they've got good reason. So it isn't an absolute 6-month ban. But as administrator, what you are going to be interested in is when can you or your client take steps to start distributing the estate. And because the court has historically been quite indulgent around Section 4 extensions of time, you might feel that there's some level of concern about taking steps even after the 6 months have expired to distribute the estate. Well, rest assured that you won't get penalised if you wait 6 months and then start administering, even if the claim is made after that period of time, because there is protection under Section 20 of the Act after the expiration of 6 months from the date of the grant if you do start distributing. But you would hopefully be aware before that happens of a claim, because most represented claimants who are engaged with the estate and with the testator would hopefully notify you before that happens by way of a letter of claim, or quite often a caveat in the estate notifying you of the intended action. But you do have that statutory protection against distribution. So responding to the claim is quite specific as far as executors go. You are going to be a defendant to the claim, and that is a statutory requirement. The defendant must file an acknowledgement of service within 21 days of the claim. So just be aware, the probate rules say 28 days, Inheritance Act claims say 21. A defendant who is a personal representative must also file and serve a written statement of evidence, which includes the information required by the Practice Direction 57. Again, the role of the executor is to remain neutral. So Practice Direction 57.15 requires a defendant who is a PR wishing to be neutral to say explicitly that that's the case in Section A of the Acknowledgement of Service form. Section A looks like this. You have a box to say, I do not intend to contest this claim, and that's the one you should complete. And it's probably safe just to be absolutely clear that you intend to remain neutral and intend to be bound by any decision of the court. You've got a box there that you can see where you can complete that, and I would suggest wording to that effect. The written evidence of the PR is set out quite clearly in 57.16 of the CPR Practice Direction, and I've simply copied and pasted it onto this slide. You must give full details of the value of the deceased's estate, sorry, net estate, as defined in Section 25(1) of the Act, the person or classes of persons beneficially entitled to the estate, their names, and the names of beneficiaries, the value and interest of the estate so far as they are known, whether any living beneficiary is a child or person who lacks capacity, and any facts which might affect the exercise of the court's powers under the Act. So you might be, so there might be an issue about the domicile, for instance, of the deceased, because the Inheritance Act applies to persons domiciled within the UK. So if there is a question mark about that testator's domicile, then the executors should be making the court aware of that in relation to their written evidence. And I should also point out that Inheritance Act claims are not specific to wills, where there's been a will and somebody doesn't, somebody's been left out the will or not been left enough provision. They also can apply to intestacies. So where the intestacy has not left sufficient provision for a particular person as a result of the intestacy rules, then that person can make a claim as well. The practice direction requires the PR to produce the original grant of representation on the hearing of the claim, so that's at the end. And if the court makes an order in relation to the claim, the original grant, together with a sealed copy of the order made by the court, must be sent to the principal registry of the family division for a memorandum of the order to be endorsed on or permanently annexed to the grant, in accordance with section 19, subsection 3 of the Act. And the order must make a direction for the above to happen. So that's your job as executor, to make sure that when an order is made that would affect the distribution under the will or under the intestacy provisions, that the principal registry is notified of that change as a result of the order by having the order written on the grant or attached to it, and the order in itself directing you as executor to take those steps with the principal registry. So that is something you will want to make sure is included in any settlement, for instance, that happens during the claim, whereby an order is made recording those terms, because that order must include this provision so that you can then properly administer the estate in accordance with that settlement. And there are interim orders that may be made in the context of the Inheritance Act claims as well. Most commonly is an order for interim provision for the claimant if he or she is in immediate need of financial assistance and there are sufficient assets in the deceased net estate to be able to make an interim order. So that again, these cases taking a long time to conclude, and a claimant's claim is based on their immediate need. So they may be asking you as the executor to make some payment to him or her before the final determination. So you would be served with the application for interim maintenance, and you will then have to respond neutrally to the application, but with the intention of informing the court what assets are in the estate, what can be made available to meet the need of the claimant, and alerting the court to anything that may be of concern to you. So there may be that although there's no liability at present, there may be an anticipated liability that might then make this estate insolvent or something like that. So these sorts of things need to be raised by you to alert the court to the position so the court can make a decision. And section 20 of the Act again protects you if it does transpire that there were not sufficient assets at the time to meet the claimant's interim need, but then but at the time you thought there were, that you will be protected as long as you give the court a true account of the position and give as much assistance to the court as you can. And there are other things to bear in mind as the PR when you're responding to a claim setting out the value of the estate and its assets. Think about whether there are any other claims that might be made against the estate. For instance, a claim under Talata. Quite often happens where it turns out that maybe the estate held a property, but then a child comes forward to say, well, actually, I'm beneficially entitled to that property because I gave my parent the money to buy it, and they might bring a claim against the estate to say that that belongs to them. That, of course, would deplete the net assets in the estate. So bear that in mind. That also applies to probate as well, because there are instances where that the asset, if the asset of the estate is compromised, then the probate claim might be not worthwhile if there's actually nothing in it. So sometimes you find probate claims are stayed pending another claim being determined, and so everybody knows what actually they're fighting over. And there may also be liabilities that the estate has, so claims against it for debts and promissory estoppel claims. And again, if anything is likely to impact upon the value of the estate, then that sort of information ought to be provided to the court in relation to the Inheritance Act claim. Finally, costs. In Inheritance Act claims, costs of the PR are usually paid out of the estate on the indemnity basis, and that's 46.33 of the CPR, and the case of Allsop, Wilson and Neary. Again, we have exactly the same scenario in Inheritance Act claims as we did in probate claims, but if the PR has acted otherwise than in a neutral capacity, so they defended the claim as beneficiary of the estate, for example, costs of doing so will not be recoverable from the estate on the indemnity basis, and he or she could be ordered to pay costs. And that's the sort of situation that arises where a child, for example, is appointed as an executor but is also a beneficiary, and they will wear two hats. And you, as executor, you may be acting for the beneficiary as a litigator, and you may also be acting as a representative of that party in relation to their duties as an administrator. And it's important to make the clear separation between the two roles to make sure that from a costs perspective, your client is protected. And the usual rule is that the winner pays the loser's costs in Inheritance Act claims, but the PR's costs come out of the estate. So I hope that's been a useful run through of executors' obligations. As I say, I'm sorry that Ryan wasn't here today, but I hope that's covered everything. Please complete any questions that you may have in the question box, which you'll see in the side panel, I think, of your dashboard, and I will respond to those. If you have no questions today, then I wish you a very happy Friday, good weekend, and thank you for joining me this afternoon. No. I can't see any questions. So please email me if you have any questions. Otherwise, enjoy the rest of your day. Thanks very much. Bye.